All right. Okay, well, thank you all for joining us this Tuesday night and taking time out of your evening. We are Expunge Colorado, and today we are going through this special webinar specifically on drug convictions and an eligibility overview of record sealing drug convictions in Colorado. And before I begin, I do want to give a special shout out to our partners and sponsors, Wana Brands Foundation, Wana Native Roots, Wild Terrapin Care Station, and Interfaith Alliance of Colorado. And here we go. We're going to get into it. Okay. So today's webinar is going to focus on, first, we're going to tell you a little bit about who we are, Expunge Colorado. We're going to give a brief overview of the war on drugs. Rosalie is going to take us through that. And then Abby will lead us through the legal parts of the webinar, where we're going to speak specifically about drug-related convictions. And convictions are just a plea of guilty or found guilty at trial. What we are not discussing today is arrest with no charges filed and non-drug related convictions. And we are going to also talk about the petition-based sealing versus auto sealing. Auto sealing became in effect last year through Senate Bill 99. And here in the corner, there's a picture of Governor Polis signing SB 99 into law. We're going to just give a disclaimer here that, you know, this presentation is not legal advice. It is for informational, educational purposes only. If you do choose to represent yourself, you are bound by the same rules and process as a lawyer. And if you do not have a lawyer, or if you do not understand this information, please contact a licensed attorney. We are going to utilize the chat for questions, and we're going to do our best to address them at the end. And we, just so everyone knows, we aren't able to discuss individual cases. All right, so who are we? We're Expunge Colorado. We are a women-led, BIPOC-led, Colorado 501c3 nonprofit dedicated to providing education and access to legal services for record sealing of eligible criminal records in Colorado. You are meeting tonight our three co-founders. This is me, Melanie Rose Rogers. I'm a co-founder and also a director of development. And then I'll introduce Rosalie, and Rosalie will also introduce Abby. But a little bit about me, you know, I'm Filipino. I've been living in Denver for 15 years. I have my own company called Influential X, rooted in education, advocacy, and social responsibility. I care very much about drug reform, also criminal justice reform in the work that I do. So that is a little bit about me. And then about us. So since 2018, we started as a group of volunteers, and we've hosted 5 annual clinics free of charge for the community. Since 2018, we've reviewed 500 records for eligibility, and we've sealed approximately 140 records from public view. We also have recruited and trained over 100 lawyers and students, and we have offered continuing legal education credit for legal volunteers. We've worked with over 25 organizations to provide wraparound services at our events. And we are also, Expunge Colorado is part of the Clean Slate Coalition, and we supported the passage and implementation of Clean Slate legislation, which is Senate Bill 2299, which automated record sealing in Colorado. And Abby will talk a little bit more about that. But below you can see, you know, our timeline. We started really as 3 people coming together during what was called National Expungement Week, which was a national push for cities to put on an annual record sealing clinic. And every year, these are kind of our results, and we've been growing. The three of us are, we started as volunteers, and we've put on an annual record sealing clinic. And so this is a very special webinar because we're offering education. Specifically, we've tailored this to drug convictions because, as you know, 420 was just last month and weeks ago. And that's usually a time where, people are celebrating. However, we also know the impacts of what the war on drugs has done with people with previous cannabis convictions, with drug convictions. And we really do know, the hurdles. We hear them every year at our clinic of how a criminal record can impact a person's life many years later, even after their time was done. And also we understand how complex this process is for record sealing. And a lot of people don't know that, in Colorado, we do have robust laws where, we have actual record sealing, laws that are able to provide relief. And actually, 1 out of 3 people in Colorado have a record. So our work speaks for itself. We come back every year. Our clinics are usually hosted in the fall, like around the end of September, mid-October. And we can talk about that a little bit more at the end. But today's presentation is specifically around drug convictions. And so, yeah, just wanted to share some of our results so you get to know who we are. All right, and with that, I'm going to introduce Rosalie Flores to take us through a brief history on the war on drugs. Rosalie? You're on mute.
There we go. Thank you. Thank you everyone for joining. My name is Rosalie Flores. I'm Executive Director of Expunge Colorado. I grew up in the heart of the 90s in the war on drugs. And so when I learned this information, the background of the war on drugs, it really kind of helped me dispel some shame and some responsibility that I felt that I had for the outcomes within our community. So I hope that learning some of this information, please share it and pass it along. It's not taught in law school. It's not taught in high school. Learning about the war on drugs and really understanding its implications are super important when it comes to changing how things go in the past. So I'm going to start, the war on drugs. How did it start? How it's going? I'll just say a little tiny brief history on cannabis. Although there's evidence of cannabis use from prehistoric times, it is generally assumed that cannabis was introduced to the Americas largely by enslaved Africans and European colonizers. Although at the time of European contact, indigenous people of North America smoked as many as 100 different plant species. Fast forward to the revolution in 1775, hemp was a necessity for the American Revolution. It was a huge need for the economy. And in the 1800s, cannabis products were legal to purchase over the counter and in the US. You could buy cocaine toothache drops in the Sears catalog for $1.50. Opium dens were also legal, just as alcohol bars are today. So how did it go from being accessible to being criminalized? Well, the truth of the fact is the policies behind drug laws in the United States traditionally and historically have been systematically driven by racism, just bottom line. I heard this the other day and I just resonated with it. The war on drugs is a US-made human rights disaster that has deliberately targeted Black communities and other communities of color and ethnic minorities around the world. This is why I feel it's so important for individuals who've lived in communities of color and who are understand that this was very intentional. The first anti-opium laws in the 1870s were directed at Chinese immigrants because opium smoking was markedly a Chinese practice. The first anti-cocaine laws were directed at Black males in the South in the early 1900s based on a racist fiction that violent antisocial behavior demonstrated by Black men was linked to cocaine use. And in the 1920s, marijuana began to be viewed in the Southwest as a direct cause of Mexican lawlessness. So how did this start? Let's learn a little bit about who started it all. And I hope you all remember his name and Google him and There's some really great YouTube videos about him. His name is Harry Anslinger, the man behind it all. There's also a really great book called Chasing the Scream that talks about his origins. But if you read this quote, you can get a good sense that Harry had an agenda. And I'll talk about how that started. In the early 1900s, things really started to shift. Let me tell you a little bit about what was happening and to give some context. Immigrants from Mexico were fleeing the Mexican Revolution, and that threatened many Americans as competition for employment, especially during and after the Great Depression. White Americans and many in power were also concerned that Blacks, Asians, and Mexicans could not assimilate as easily as the European immigrants that were entering the country very easily. And that was resulting in great racial tensions. So enter this man, Harry Anslinger, the man solely responsible for the prohibition of cannabis. Harry established the Federal Bureau of Narcotics in 1930 because he knew alcohol prohibition was coming to an end. The agency was not created because of societal harm, but because of a loss in tax revenue. He knew cannabis was not harmful, but the truth is he was racist and he hated jazz and jazz musicians. He demonized racial and immigrant groups through their use of cannabis and literally convinced the entire world to make it illegal. All this was done to help fund his newly formed agency. He effectively silenced anyone, including doctors, who spoke against him. And it was Harry who popularized the term marijuana because he believed it would associate the drugs with Mexican immigrants and play into the phobia over the border. Also at this time, oil and gas interests and the largest newspaper invested in paper were opposed to hemp production for industrial use because it cut into their profits. So they made political moves to ban hemp. Starting in 1936, we began to see movies like Reefer Madness, which was about a group of young students whose tragic downfall was caused by their marijuana use. The movie was followed for years after with false propaganda campaigns to enforce the misconception that cannabis is dangerous, and before long, everyone believed it was true. Although there were significant acts passed decade after decade to set, then increase mandatory sentences for drug possession, it wasn't until the 1970s when the war on drugs was officially declared. We've just learned it was going on for many, many decades before that. Nixon, who has also been dubbed by historians as a racist, initially saw drugs as a public health issue, but he quickly changed tactics. Nixon created the Drug Enforcement Administration, which started out as 1,400 special agents with a budget of less than 74 million. Today, the DEA employs over 5,000 agents and has an annual budget of over 2 billion. By the time the Just Say No campaign launched when Reagan took office, the foundation was laid for maximum punishment for drug offenses. From 1980 to 1984, the number of arrests for all crimes had risen by 28%, but the number of arrests for drug offenses rose by 126%. So now prisons needed to be built, and the war on drugs created ample opportunities for businesses looking to make money, and the private prison model began to boom. Congress then passed the Anti-Drug Abuse Act of 1986, which allocated another 1.7 billion to the war on drugs, and which established mandatory minimum prison sentences for drug offenses. And the 1994 crime bill, written by now President Joe Biden, accelerated mass incarceration, incentivized localities to build more jails, and increased prison sentences and eliminated the possibility of early release for incarcerated people. So conversations have started to shift in the early 2000s, and progress has been made. People are starting to look at, let's address the root causes of incarceration. And some of those attempts have been what we're living in today, cannabis and drug legalization. Recreational use of cannabis has been legalized in 22 states, and another 9 have decriminalized. I think there's all but 6 states in the entire country that don't have some type of cannabis reform laws. This just applies to cannabis. However, although states are moving towards legalization and voters are more accepting of marijuana sales as a way of increasing revenue, arrest discrepancies are still staggering. In 20 states, racial discrepancies in marijuana possession arrests increased by 25% or more, and in some states up to 100% more. Latino and Black communities are still victims to outrageously disproportionate drug enforcement and sentencing practices. A report put out by ACLU found that although rates of marijuana use are the same of all races, Black people are 3 times more likely to get arrested. This disparity has not improved with changing cannabis laws, and in fact, it is worsening in some locations. And during the time of legal weed, adult arrests have went down, but Black and Latino youth were being arrested at disproportionate rates compared to their white peers, whose arrests went down. It's still continuing on today. And unfortunately, one of the few demographic surveys done on ownership in the cannabis industry found that 81% of cannabis business owners and founders were white. Here in Colorado, the proportion of Hispanic Latino owners are 5.7% and owners, while 4.3 are Black and just 2.4 are Asian. There is no, there's no number for Indigenous owned businesses. So we'll like to mention legalization is often sold as a means of repairing the harms from the war on drugs, but it can't necessarily be accomplished if average individuals and those that are most harmed are excluded and not able to enter the industry. Other ways that attempts have been made to repair from harms from the drug war, reinvestment into unjustly targeted communities, and that's from cannabis revenue. That's happened here in Colorado quite a bit. Now people are looking at treatment versus incarceration and harm reduction methods. There's been some progress on progressive versus punitive legislation and law enforcement assistance diversion programs. So there's conversation, and all of that has shifted a little since 2020, but we'll learn a little bit more about how it shifts back and forth. It seems like progress, and then things change. But one of the major ways that we can repair harms from the drug war is through record sealing, and that's why we're here. And this is what can instantaneously change lives. So let's talk a little bit about record sealing here in Colorado. Just give you a little bit of context. When an individual seals their record, they immediately make 25% more in their income. It just changes lives. We had a participant from our clinic that was able to get an organ transplant because of this. Another one that was able to volunteer with their grandchild's school. So it can instantly change your life. And that is why this is such a passionate work project for us. Colorado is one of the few states that allows for sealing of both misdemeanors and felonies, and it actually has less waiting times than many other states do. You look here, and since 2011, Colorado has changed its laws on record sealing, steadily expanding the range of records. And in 2013, it was when the legislature created a separate drug grid and reduced the felony penalty for possession of Schedule 1 and 2 drugs. It still remained a felony until 2019 with the passing of HB 19-1275, when community groups and criminal defense community came together and made simple possession for Schedule 1 or 2 drugs a drug misdemeanor with certain conditions on whether people could be jailed and mandated probation and not forced to go to jail. That was just 2019, just a few years ago. We've made these kind of changes. And last year, 2022, Colorado became one of 5 states to pass legislation to automate the record sealing process, known as clean slate laws, passed this past session. And we were involved with that, and are very glad to see it happening, because as you will see in this presentation, this isn't easy. And I'm going to pass it on. Let me quote one more. And just talk a little bit about when you do have a record that's sealed, you can, and we say sealed, not expunge. Expunge means destroyed from public view. Juvenile records in the state of Colorado are expunged. Your adult records are not expunged. They're sealed from public view, which means that you can effectively deny the existence of a sealed record, and you're not required to disclose sealed records on applications. The defendant and all criminal justice agencies can properly rely upon that the records do not exist, and you will not be denied solely because of the fact that you have a record. But law enforcement, courts, and judges will always have access to a sealed record. There are some exceptions to this in some industries. The Bar Committee and the Department of Education may be able to see a sealed record. So we're going to get into the nitty gritty now of drug convictions here in Colorado. I'm going to pass it along to Abby Moffitt, our Chief Legal Officer. She makes all of this work possible. And take it away, Abby.
Okay, great. Thank you everyone for being here this evening. I'm going to go over Briefly, what drug convictions are eligible and an overview of record sealing. But first, just to let you know who I am a co-founder and chief legal officer of Expunge Colorado, as we've talked about. I've been an attorney in Colorado for 8 years. I started as a public defender here in Colorado in Jefferson County, and then I went into private practice, and I've had my own law firm since 2019. And that's A. Moffitt Law. And so I practiced criminal defense, and I, on the team, help train lawyers and do the process side of the clinic of filing the petitions and everything that happens afterwards. And so determining whether or not your record seal is eligible to be sealed is a big barrier when we get into our clinics and see if we can seal someone's record. And so we're hoping that this presentation can give you a brief overview of knowledge of whether or not your conviction or a conviction in general might be eligible to be sealed. And we're just focusing on drug convictions today, not other types of convictions. For some context, not every type of conviction is eligible to be sealed in Colorado. It's determined by the Colorado legislature through law what certain types of convictions are eligible to be sealed and which aren't. So I'm not discussing all types, but just for example, felony crimes that have a victim are generally not eligible to be sealed. Those types of crimes aren't. So I'm just going over drug convictions today. And when I talk about drug convictions, I'm talking about convictions that are related to a controlled substance. So that would generally be possession, manufacture, cultivation, distribution of a controlled substance, because I know there can be potentially drug adjacent convictions that occur, but I'm talking about things that involve convictions specifically that involve a controlled substance. And when I talk about convictions, as Melanie said in the beginning, convictions are when the defendant has pled guilty or been found guilty at trial. So there's a conviction on the record, just to be clear about that. So tonight, I'm also going to go over the petition-based process versus auto sealing. These are two different ways that someone could potentially have their record sealed in Colorado. The petition-based process is what we help with at the clinics that we put on. A petition is a form that you fill out, that you file with the court, or defendant files with the court, asking the court to do something. So you're petitioning or motioning the court. It takes action from the defendant or the defendant's counsel to put that ask before the court. And the petition-based process is discretionary for convictions, which means that it's up to the court, the judge, whether or not to grant that petition once it's before them. And for the petition-based process, there could be a hearing potentially, kind of just depends on the level of the conviction. And then the waiting periods for the petition-based process, and we'll get into waiting periods in a little bit, but generally a defendant would need to wait a certain period after they've been done with their conviction in order to apply to seal. And the waiting period for that is generally less than the petition-based and the auto seal process. So auto sealing, on the other hand, is when the government creates a roll or a register of all the convictions that they have on file, and they cross-check them with the DA, and then they send them to the court, and the government on their own seals a conviction that's eligible to be sealed. There are longer waiting periods for auto seals, and there's some potential problems that could come up with auto seal that we'll talk about later. Auto sealing is new to Colorado. As we've talked about, it was implemented with SB 2299 in August 2022, and it's set to roll out in 2024. So it hasn't begun yet, but it's something good to be aware of. And then, as Rosalie just said, good to know what the effect of sealing is. So if you have your record sealed in Colorado, it means it's sealed from public view. It won't appear on a public background check. It is still accessible to law enforcement, to government agencies, the court, the prosecutor, and other government agencies. So sealing a record is most beneficial if you're applying for jobs or housing. There can be other benefits as well too, like volunteer opportunities. But that's the effect of sealing a record in Colorado. Okay, so the good news is that drug convictions in Colorado are generally eligible to be sealed. There's definitely caveats that I'll get to, but for the most part, drug convictions are eligible to be sealed if these 3 certain criteria that I've listed here are met. And I'll talk about each of them in further detail in further slides. But the first is a conviction would be eligible to be sealed if the defendant has not had a new conviction since the final date of their case. I'll talk about what final date means. And then the second criteria would be if a certain waiting period has passed, depending on the level of their conviction, the level meaning the class of the felony or misdemeanor. So in Colorado, there are 6 classes of felonies, 4 classes of drug felonies, and 3 classes of misdemeanor and a drug misdemeanor. So depending on the level. So if a certain period of time has passed since the final date of the case, you've got to wait that period, then you could be eligible to be, the defendant could be eligible to seal their record. And then the last criteria is if no restitution is owed. And so just to go over that again, so a drug conviction is generally eligible to be sealed if the defendant does not have a new conviction after the final date of their case, if they've waited the appropriate period of time since the final date of their case, and then if no restitution is owed. And generally for drug convictions, restitution is not a part of the case. Restitution is generally if there's a victim in the case and the victim needs to be made whole or has some damages that need to be paid by the defendant. But in general, drug convictions are victimless crimes, or there's not an assigned victim for a drug conviction. And that's another reason why drug convictions are generally eligible to be sealed. A lot of times with other type of convictions that have victims, there's less, the legislator is less inclined to want to give those defendants the right to seal their record. But for drug convictions, we've seen that the legislator is open to granting the ability to seal a record if these certain criteria are met. And so what's a final date? Because that appears in both of these. The final date of the case for this purpose is either the date of the disposition, so the date someone pled guilty or was found guilty at trial, or the final date of release from supervision, whichever is later. So generally the final date of a case is the last day of probation or jail sentence or prison sentence or the last date of parole. That would be the final date of a case. So for example, I'm going to use some examples throughout just to illustrate this. So say someone is convicted of a class 3 drug felony, distribution of cocaine, we'll say in June of 2011. They're sentenced to 2 years of probation in June 2011. So they complete probation 2 years after it. The final date is June 2013. And I'll use that example again. So I'll go over each of these in a little bit further detail. So what do I mean when I say the defendant cannot have a new conviction since their final date in order to be sealed? Great. So generally, only the most recent conviction on a defendant's or someone's record is eligible to be sealed. And that's because you must provide, when you file a petition to seal with the court, you must provide the court with a copy of your or the defendant's CBI record. And we have a link to where you can pull a CBI record on your own. This costs $4, but you can pull your CBI record and see what's there. If you do file a petition to seal your record, you need to include that record and give it to the court. And it's got to show to the court that the defendant has not been convicted of another offense since the final date of their case. There are a few instances where if someone has multiple convictions, they might be able to seal their record, although it's limited. This is kind of a new part of the law too, but it is really limited. So for multiple convictions, it's generally limited to, like, if you're trying to seal multiple felonies, you can only have 3 convictions total in your lifetime, and you've got to wait 10 years. There's kind of some further criteria. So if you have questions about multiple convictions, I would suggest you do some more research and maybe seek out advice of counsel if you need to. And then the second criteria, if you're trying to seal your someone's drug conviction after, okay, we've checked and it's the most recent conviction, now we need to determine if the waiting periods are met. And this is the next slide. So on this slide, it will show you generally when a drug-related conviction is eligible to be sealed. And this is for that petition-based process that I've talked about. So on this chart in the left-hand column, I've listed the different levels potentially of offenses. And in the right-hand column, the amount of time that they need to wait in order to seal their conviction. And so again, this is determined by the legislator. They've created these timelines and this grid, this criteria. So in order to, you might be asking, how do I know what my level of conviction is? That's something that you would find in your court records. If you don't have like a copy of your court records anymore, you can get that from the court, or you can go to coloradocourts.com, and we'll show you these links later in this presentation. And in that, you'll click on your case, and it will tell you the level of your conviction that the guilty plea is associated with. And so it will show you, if it's a misdemeanor or a misdemeanor class 1, misdemeanor class 2, misdemeanor class 3, or felony, which class, or drug felony, which class. And so you'll see here, like for drug petty offense, you need to wait 1 year after the final date of the case in order to even be eligible to apply to seal your case. And then for drug misdemeanors and a certain DF4, this is related to, I won't get into that specifically, but you can also see in your Colorado courts record what specific statute number the plea was to. So for drug misdemeanors, the defendant would need to wait 2 years after their final release from supervision. And then for drug felonies, 3, 4, felonies 4, 5, and 6, and class 1 drug misdemeanors, the defendant would need to wait 3 years after the final date. So just using that example again, I'm going to say for someone who's convicted of a class 3 drug felony, saying it's distribution of cocaine, let's say it's in June 2014, they're sentenced to 2 years probation. That means the final date would be June 2016. If they're sentenced in June 2014, its final date's June 2016. And then we'll look on this chart and look for DF3, so drug felony class 3. So this defendant must wait 3 years after the final date of release from supervision before they're eligible to petition to seal. So that date of eligibility would be June 2019. And if that person has no new convictions since that date, if this case was the last one on their record and they don't owe restitution, then they would be eligible to petition to seal their case. It'd likely be granted, but it would be up to the court since it's discretionary. And the court has the authority to set hearings too, if they choose to, for anything other than a petty offense. Okay, so that's generally what drug convictions, what criteria needs to be met in order to seal a case, but there are some other limitations that I want to get into. To make very clear, an important limitation to know is that certain felonies and drug felonies are never eligible to seal. And that's class 1 felony, 2 felony, and 3 felony. those are generally the most serious types of felony. Those are not eligible to be sealed. And then class 1 drug felony is not eligible to be sealed either. So the class 1, 2, 3 felony could apply to drug convictions. And that's because, as Rosalie talked about, the laws changed over time to reclassify drug offenses. So at one time, drug offenses were just considered felonies, not drug felonies. But a big exception that I'm going to get to on the next slide is that for drug convictions prior to 2013, they should be considered by the offense level of what they would be today. And this was a change that occurred in the SB 2299. And it makes a lot more drug convictions potentially eligible to be sealed. Like I said, I'll get into that in a minute. And then just some other general things to be aware of when petitioning to seal your case, and this is true for sealing any type of conviction. You must be able to seal your entire case, meaning if one conviction is not eligible, the whole case is not eligible. So for an example of this, say someone has pled guilty to a class 3 felony theft, but then they also have a class 4 drug felony, possession of a controlled substance that's eligible to be sealed. Because of the class 3 theft, and because class 3 felonies are never eligible to be sealed, that entire case is not eligible to be sealed. It's not possible to pick apart a case and only seal certain parts of it. You have to be able to seal the entire case in order to seal it. Also, a petitioner can only file a petition to seal their case once every 12 months, and that would apply if your petition was denied for the court. So if it's denied, the petitioner must wait 1 year before applying again. And then also if someone's case is sealed and then that defendant is convicted of a new crime, their sealed case would become unsealed. And just to know, this webinar is just intended to give you, general knowledge of what's eligible to be sealed. But if you have any questions, every case can be different. And there are some other things, could be some other things to be aware of. So in the next slide, I want to get into that change that happened this year. This went into effect in August 2022. And the change is that for determining eligibility of a drug offense committed before October 1st of 2013, the court should consider what the conviction offense would be classified as today, rather than what it was at the time of the offense. And that's not true for other types of offenses or for drug offenses committed after 2013. It's just for drug offenses that were committed before October of 2013. And that's because that's when that change to the classification of drug crimes occurred in the legislature. And so this was an acknowledgement that I believe that there was an over prosecution of drug offenses prior to 2013 through the classification of crimes at that time. And it's an acknowledgement that today some of those crimes would be eligible, and so they should be taken by what they would be today. And so I'm going to go over, it's very difficult. I can't really give you a chart of what would this offense be in 2002, or what would this offense be in 2010 versus what it would be today, because there are a lot of different offenses related to controlled substances and they changed over time. So it's difficult to give you that analysis of what it would be specifically for all the offenses. But do know, I want to talk to you about this example and how you might go about determining it, and if this could apply to you potentially. So it is difficult because a lot of the classifications for what drug offenses are determined by weight, and the weight can be, the weights related to the charges can be different. And so it could be that you need to get more information about your case. in order to determine if you might be eligible for this. So I'm going to go through the example and talk to you about more what I mean by that. So we had from our most recent Expunge Colorado clinic in October 2022, we were able to see if we could implement this new change in the law. And we saw a case where someone was charged. It was from October 2002, and they were charged with a class 3 felony. It was distribution of a Schedule II controlled substance. Cocaine was the substance. So generally, class 3 felonies are not eligible to be sealed. But looking at the case, I thought maybe this could apply where we can use this new law, where we should consider it by what it would be today. And so at that time in 2002, that law said that it was unlawful to distribute any amount over 1 gram of a Schedule II controlled substance. That was always a class 3 felony. And now we know that, I just knew that it's become, the weight is larger now of what's allowed. So I needed to go to the court and request the arrest affidavit, request more facts about the case to know what was the specific weight in the case. And so I requested the arrest affidavit through the court and found that this specific offense, it was alleged that this person sold $40 of crack cocaine that was 2.7 grams. Okay, so now I know it's 2.7 grams. And today, unlawful distribution of a Schedule II controlled substance, if not more than 14 grams, is a class 3 drug felony, a DF3. So I know that's eligible, and I would go back to my criteria. That person was not convicted of another offense since then, and they've waited 3 years since the final date of their case. So they would be eligible, and we were able to seal that case. You can see that that's definitely a case-by-case determination. You might need the assistance of attorney to figure out if your offense prior to 2013 would be classified as something different today. But as you know, possession is generally a misdemeanor now today. But these are just good things to know to queue up to determine if you might be eligible. Okay, so that is the petition-based process. And so now I want to talk about automatic sealing of drug conviction records. This was the change in the law also that went into place in August 2022. And know that for a drug conviction to be auto-sealed, it must be otherwise eligible. So everything that I mentioned on the other slides before still applies, still must be the most recent conviction, and still must have, but there are different waiting periods, longer waiting periods, still must not owe restitution. So auto sealing means that the state court administrator, it's the government, is creating a list of eligible convictions, sending them to the DA to review, and then sending them to the court to seal. There's no action on the part of the defendant. And this chart shows you what those waiting periods are. So for petty drug offenses and drug misdemeanors, it must be 7 years after the disposition of the case. And for drug felony convictions, it's 10 years after the disposition of the case. It's 10 years for eligible felonies as well. And 7 years for other misdemeanors as well. So this is going to begin in 2014. And in February 2014, that's when the list is going to be created. And by July of 2024, is when these records should be sealed based on their final list that they put together. And also by July of 2024, the government is going to create a website that will allow the defendant to confidently determine whether their conviction has been sealed and information about how to receive a copy. And then on the next slide, we've just outlined, just put it all together for you. How long does someone need to wait based on their level of conviction, how long do they need to wait past the final date for petition-based, and how long do they need to wait for auto sealing. So you can see for the petition-based, it's usually 1, 2, or 3 years. And for auto sealing, it's 7 years for misdemeanors and 10 years for felonies and drug felonies. And just to go over a little bit, we're hoping and confident that auto sealing can help thousands, hundreds of thousands potentially of people in Colorado. But you'll see that there are the longer wait periods. There could be limits to potentially to when the government's compiling this list. The names all have to match, the dispositions have to match, and there's no manual process in place to ensure that all these records are sealed properly, and making sure that they match properly. So there's room for error basically within the auto seal process. And so that's why we still talk about this petition-based process, and someone can still petition even if they're eligible for auto sealing. They could petition earlier in time using the petition-based process. And then, like I said, just kind of an overview, there could be a hearing in the case, but generally drug convictions are, when there's a petition to seal and these criteria are met, the court is inclined to grant the petition, in my experience, and district attorneys, prosecutors generally don't object. And that's because of that there's no that these are generally victimless crimes. And especially if someone can demonstrate to the court that they have not received another conviction since that one. These are generally granted. And there is a fee for filing a petition to seal a conviction, and that fee is $65. There's also a $20 fee to send the order to seal the CBI, to have CBI seal it completely, which is definitely recommended. That's how it won't show up on the public search. And then there can be about $5 to $20 cost of pulling your record. So those are generally the costs. And then just briefly, some other types of relief for drug convictions. Want to talk about pardons, because pardons are in the news. Pardons do not seal a record automatically. There is a mechanism in place to easily seal a pardon case, but pardons don't seal it. If you've been pardoned, your pardon would still appear until you take that extra step to seal that record. As you may have seen in headlines, in December of 2021, Governor Polis pardoned more than 1,300 people convicted of possession of less than 2 ounces of marijuana. That's because that amount is legal to possess now. Prior to that, he had pardoned those who were convicted of possession of less than 1 ounce. He only has authority over state and county cases, and that's what I've been talking about today too. I've been talking about drug convictions for county court and district court cases. Have not been talking about municipal convictions. Those have a separate criteria of when they're eligible to be sealed. And Governor Polis does not have authority over municipal offenses. So he didn't have authority to seal a municipal offense like from Denver General Sessions Court. And this slide has some resources of where you can find information about pardons, and to find, I think that website can give you a little bit more information if you're curious if your case might have been pardoned. And then another resource, I said that we weren't talking about Denver municipal offenses today because municipal offenses have a separate criteria of when they're eligible to be sealed. But there is a resource called Turn Over the New Leaf, and this is ran by the Denver City Attorney's Office. And we've put the full URL on this slide because they don't have their own landing site. But you can also Google Turn Over a New Leaf, Denver City Attorney. And for low-level marijuana offenses that were committed in Denver that are based on conduct that's now legal, so that'd be possession under 2 ounces of marijuana, you can fill out a form through their website and they can help take you through the process of sealing that. And then just to wrap this all up, some takeaways from this presentation. And if you have any questions, please put them in the chat. But you heard from Rosalie about the government's position on drugs has fluctuated over time. It was beginning that there were no laws against possession of drugs or use of drugs. And then the government began to criminalize offenses related to minorities. And then certain administrations took that a step further, creating federal crimes against controlled substances and creating a controlled substance system after Prohibition. And now you've seen kind of some recognition that there was an over-prosecution of crimes and over-carceration, and now some mechanisms have been put in place by the government to right those wrongs in a way. And record sealing is a great relief. I like to talk about record sealing as a way to balance back the scales of justice, because there is an over-prosecution in our country and in our state. More than 90% of cases result in guilty pleas. And so there's many circumstances of people pleading to something. I could get into that all day, but there are many reasons why a case results in a guilty conviction. And so record sealing offers a relief for people who have, the Colorado legislature has determined that they're eligible to seal their record. And we believe in our organization that everyone should utilize that opportunity to seal their record and take advantage of that, because it can create a lot of opportunities if you do seal that from the public record. As I said, most drug convictions are eligible to be sealed. That's a really general overview, but for the most part, they are. If you have questions, I definitely can encourage you to seek out advice of a licensed attorney, but they're just subject to really those three criteria that I talked about. If the defendant's waited the prescribed amount of time, if they have no new convictions, and if there's no restitution. And we talked about the petition versus the auto seal process. And now I think Melanie is going to talk to you about some further resources.
Thanks, Abby. Thanks for taking us through that. And thanks to everyone for still sticking with us, going over something complex as this. But I do want to share some resources with you, two resources that we use at Expunge Colorado to check what's in, somebody's, record history, the rap sheet. We use these two resources. CBI, as you saw earlier in the presentation, for the petition-based process, you have to provide a recent copy of your CBI. So that's one way right here. CBI records check that you can use. And also we use Colorado courts. Colorado courts, as Abby had mentioned, there's some information not included in the CBI record. Like, for example, just to find out if restitution is owed, you would find that in the Colorado courts records. And so it's really good to kind of, we definitely use both to cross-reference to find out details of the case and some key information that you need if you were gonna, petition yourself, like on a pro se basis. And so just wanted to show you what we use at our clinics, and it's these two databases, CBI and Colorado courts. And there are some, again, when we talk about, drug reform and drug convictions, there are two bills right now happening through the Colorado legislature. And just wanted to bring attention to these because depending on if, these do pass and get signed off from the governor, there will be some possible changes and other definitions. So SB 109, this is the criminal penalty controlled substance supplier bill. This is if someone is caught sharing a Schedule 1 or 2 substance, that's a new bill. And then there's also Senate Bill 290, which implements the Natural Medicine Health Act, and that was voted on in the last election last November. And I also have worked really closely on that. And so these are just two I wanted to highlight that are happening right now. Like we mentioned, there's turning over a new leaf that's specific for Denver cannabis municipal offenses, and there's an application, and that is free of charge. So that's definitely a reference, a resource that we'd like to share with our community. And then for people looking for how to begin the petition-based process, we do have the URL here, and this is in the Colorado. This is in the Colorado courts website. And then if you go to this link, and we'll be sending out the presentation, it will show you right here in this little caption I showed you, like if there were no charges filed, there's specific instructions on how to seal those cases. If you were if you're trying to seal a conviction from county or district court, that's in there, or municipal court, or multiple cases. So you can read up on that. And then also 20% of people that we see in our clinic are people that work that don't have a conviction. So say their case was dismissed. There's a process for that, and also even more on like how to pardon or what to do with a pardon conviction. So those are some just resources we wanted to share. And also clean slate laws. Again, Colorado's really fortunate to be able to be part of the clean slate laws, having passed them last year. And so this is what, if you're interested in what's happening across the country, please check out the Clean Slate Initiative. They're doing great work. And then we only have just 2 more slides for you, and then we'll take some questions here, but we do let's really quickly before we get into questions. This is an event announcement. There's actually specific to Jeffco and Gilpin County, there's a clear your active warrant. Sometimes you might have a warrant for, failure to show up on probation. And so this is just something we think is excellent, and we wanted to share with you. This is where you can find out more from. This is a program called Fresh Start, and this is happening this Saturday. And so if you are here, especially our community partners, please get the word out about this event. Like this provides relief. People can speak to a criminal defense attorney and get back on track and completing probation. So, and also just making a plug to stay with us for updates. Here's our Instagram and Twitter and our website. And then if there's any following questions that we aren't able to answer in the last few minutes that we have with our presentation, here's my email. Please reach out to us. We'd love any feedback. We'd love to understand, what other, I'm really interested in, what additional content you would love to hear from Expunge Colorado. This is kind of new for us because we've just been really focused on our clinics every year that happen in the fall, but now we're just getting out, some hopefully valuable information that peels, the complex process of back a little bit, so you feel empowered and inspired to take action and be, more aware of what's going on. But I'm going to go check out the chat and see if we do have any specific questions. Okay. Okay, great. Oh, thank you, Benita. Okay.
Yeah, there is a question that I could take.
Okay, great. Thanks.
Yeah, there's a question from Christine. Thank you. And if anyone else has questions, put them in the chat. But the question is, can I answer no to the have you ever been convicted of a crime question if my record gets sealed? And this, if Melanie, you want to go to slide 13 and pull that up? The answer is yes, you can answer no to that question if you've ever been convicted of a crime, if you do have a sealed record. So you can effectively deny the existence of the sealed record. You can reply upon inquiry that public criminal records do not exist. Now, I will say the caveat, you can answer no if you're applying to jobs or to housing, but if you're applying to something in the government, like we said, sealing a record does not deny access to the government from sealing your record. So if you're applying for a government agency, then they will see your sealed record. And so you'll need to tell them about your record because they'll see it anyway. Yeah. I hope that's good news. But it's definitely something that it's good to be aware of, just the difference between what's expunging something and what's sealing. And in Colorado, we only have sealing for adult criminal records.
All right, great. Are there any other questions? Let me also just take us back to. I'm not seeing if there are, and let me just look. Might have one.
No, it was,
Okay.
just wanted to thank everybody for joining. Thank you so much for your interest in this work, and please share the information that you have learned today. We'd love to have people break the stigma and talk about record sealing in a very honest and clear way. So please share what you've learned and let us know if you have any feedback.
Yes, thank you, Rosalie. And just a quick shout out again to our community sponsors and community orgs. We're a 501c3 nonprofit. So, you know, just knowing that any donations made to us are tax deductible, and we wouldn't be here without the support of, you know, these organizations and many others that, you know, support the cause, you know, for record sealing. And we know the rippling impact this has for not just only the people that have, you know, offenses or charges, but generations to come, you know, children, community. This goes very far. Yeah, we're really just honored to be able to share this information. And if there's no other questions, I'm happy to give back some time to everyone's evening. You know, again, this was a very first offering for us to be able to just, you know, take something and speak to it. And especially since auto sealing is still pretty new and people are wondering, you know, what's the timeline? We wanted to speak to that. And, you know, but the petition-based process, as you saw, definitely has the shorter wait periods. And our clinics, just so you know, it's still to be announced the date, but we usually have them in the fall. And so anywhere from like end of September to mid-October is kind of what we've been really consistent with year after year. And I believe we are, and if you stay in touch with us on social media, we'll be able to promote that. And we're looking for, you know, volunteers and attorney volunteers and other, you know, people that want to help support the work. So again, thank you all for your time, and thank you for, and I hope this is able to provide just some valuable information. And I'll just pause to see if there's any other questions, but I think we might be able to just give, you know, 10 more minutes back. And we do plan on sending out the deck. So Benita, you'll definitely get that. And then if there's any other questions, again, you can reach me. I'll put my email in the chat. And that's all we have
Great.
Thank you, Jasmine.
Thank you.
Thank you.
Thank you,
all.
everyone. Have a great rest of your night. Thank you so much.
Bye.
Bye. Recording.